welcome to Your Hometown Solutions. I'm your host, Jean Newell, and in the studios with me today is my co-host, Jonathan Lack. Hello, Jonathan.
Hello, Jean.
We're here discussing all kinds of things that you need to know about elder care. And in the studios with me today is David Slonim. Did I say that right?
You did, David Slonim. That's right.
At the Slonim Law Firm. And tell us a little bit about your company and what you represent with the elder care.
Sure. So, again, I'm David Slonim. I'm an elder law attorney, and I've been in practice for myself since about 2005, and we've had the office here in Melbourne since that time, and then have expanded throughout the state. We've got other offices in Kissimmee and Jacksonville as well, and we specifically handle only elder law matters, essentially. And what that covers is, of course, wills and trusts, estate planning, and then we also do probate and guardianship and Medicaid planning, so a lot of help for government benefits with respect to seniors. And also we're getting into digital estate management, which is a new area that really covers the person's online identity during their life and after they're passing away.
Well, I think today we're going to talk a little bit more about estate planning because there's a lot of things to discuss, and we've had a lot of people sending in questions to us to ask you. So let's really get into elder care and estate planning. So here's our first question that came in. It says, I bought my home that I live in before marriage. Can I leave it to my kids, skipping my spouse?
Well, the spouse is going to be entitled to having that property. Once, of course, you're married there, there's a spousal empowerment issue under the Florida law there. So the short answer is no. However, if there's always caveats to that being the law, and so you can discuss whether or not you have any prenup or postnup agreements that are in place that are going to be potentially affecting that situation there.
I bet you would see that a lot with older marriages where they have two completely different families, and then that gets a little muddy, I would imagine, with the grandchildren on both sides and children on both sides, and so that would fall under that same question. You want to make sure you have it up front in your planning or your estate planning, or how would you address that?
Sure,
with two different families that are down line of the probate.
Right, yeah. Blended families are certainly an interesting topic. And we see that, of course, quite a lot. And so, there's a lot of additional planning that should be had when it comes to dealing with a second marriage or further marriage situation there. When there's, different kids and different priorities that the parents or the couple is going to have, then we want to make sure that we address all of these things. And, what they may want is not necessarily what is going to happen according to the law. So they have to understand what their wants are and what's going to actually be the process throughout the statutes and whatnot.
That's why they need to see you before they start setting these things up, because they might think I've got it all covered because I went online and I did my will for $49.
Right.
In reality,
right. We love those. Yeah.
They might not have a clue what's really going to happen. While we're talking about that, why don't you give out your website, phone number, any information that they can, so people can get a hold of you and maybe set up a consultation.
Sure. Again, the firm is the Slonim Law Firm, and you can go to slonimlaw.com online, and the phone number is 321-757-5701, and that's the phone number for the Melbourne location, and they can go to the website to find the other locations and the phone numbers.
And spell your last name.
Sure. It's S-L-O-N-I-M, and that's, again, SLONIM. LAW.com, right?
Great. You have a question?
Yeah, well,
Jonathan?
I actually wanted to continue with the skipping the marriage or skipping the spouse situation. I've had many circumstances where, as you call them, blended families, a second marriage, and there might be differing children, and so the spouses come to me to do separate wills wherein they each to the other, but then remainder to their respective children.
Right.
Is that a situation that can be accomplished with a will?
Yeah, I mean, they can to a certain extent, although, again, it just depends as to what their assets are and how they're going to be titling those. So basically, if they've got some property, such as real estate property, that's either local or even in a further state, then, they may want to be looking at a certain revocable trust or other solution there. They have, other alternatives as well as so what's called POD or TOD, that's payable on death or transfer on death, to say how that particular asset in a financial institution is going to get distributed. So, a will is basically the instruction manual for probate, and that's something that needs to be understood by the people that are looking at this as far as their planning, is that a will is not the end-all, be-all. It's just going to cover this particular probate situation. It's not going to necessarily cover how any other assets going to be distributed otherwise if there's beneficiary designations or whatnot.
We jumped right into the show because we had so much to cover, and I didn't really get a chance to introduce Jonathan. Tell the audience a little bit about your background and your specialty in law.
All right. Well, thank you, Jean. Again, it's Jonathan Lack. I'm with the law firm of Lack & Lack Chartered, and we're primarily a transactional real estate firm, and so a lot of my experiences tie in nicely with David Slonim's experiences on the probate and trust and estate planning side, because obviously, when people are planning their estates, their primary concern is their real estate and how to deal with that. So our practices blend nicely together. Also, as you know, Jean, I am the broker-owner of Waterview Realty Services, of which you are my finest agent, and I thank you. And so we at Lack & Lack and Waterview Realty primarily work with transactional real estate matters.
Okay, so we have...
I guess I should say we can be reached at area code 321-953-5115. And Waterview Realty, its website is waterviewre.com.
And for those of you that have been listening for the last year and a half, we have changed our location. That's want to give out the new address?
Oh, yes, thank you. The new address is 1165 North Highway A1A in Indy Atlantic. We've moved just about a mile north. The beauty of our new location is Waterview Realty is now officially Waterview, as we are on the ocean looking out over the Atlantic every day. It makes it for a very pleasant work experience.
Actually, you are looking over the ocean. The rest of us don't get a water view.
Well, you can look out the window.
But aside from that, we try to make sure that you know all of your professionals in the area. So if you have a question concerning real estate, maybe you're trying to sell your home yourself, or maybe there's a situation where you're behind on your payments. There's all kinds of things that Jonathan can handle for you, because we're going to be talking about that in a future show about the Hardest Hit program and things like that. But today is all about what you need to know, especially in the elder care arena. Did you want to go ahead and ask the question from Vieira?
Yeah, we did have a question from a young woman who was probably not that young, but in any event, she had said that my husband has dementia and the bank won't let me refinance our house. So, David, how do you handle situations where somebody has become legally incompetent? How does one deal with that?
Sure. So if a spouse becomes incapacitated and there's a need for the other spouse to have some control over the realty, then the first thing we're going to look at and see is whether or not there is a power of attorney in place. Even though a couple is married, then they don't have automatic authority to handle another person's assets. So, the husband and wife are still independent individuals. And so that's where the advanced directives, that's the power of attorney, the healthcare surrogate, the living will, and the prenatal guardian declaration are all going to be super important. And if we don't have those documents, or if the person is unwilling to accept the control of the person named as the agent, then unfortunately we've got to go to court and get a guardianship situation going, and that's generally not the most pleasant of experiences. So the power of attorney is a great way to be able to have the spouse be able to step up and act as the agent for the other spouse to be able to speak on their behalf to the mortgage company and whatnot.
And I think it's important to note that there is a difference between a power of attorney and a durable power of attorney. For those who might choose to look on the internet and look up power of attorney, it's very important that you have a durable power of attorney. The durability means that it survives this incompetence, because a power of attorney is only good for the person if they can sign it themselves.
Yeah, and that's a really good point, Jonathan. I mean, the situation that presents itself now in 2017 is that actually back in October 1st, 2011, there was a major change under Florida law for powers of attorney, specifically durable powers of attorney, where there used to be what's called a springing power of attorney, and now the standard power of attorney. And the thing is with these durable powers of attorney is that they're effective now as soon as the maker of the document, are signing that document. So the person that you're naming as your agent can act right away. And while that may be a cause for concern to some people, you really want to make sure that you're naming the people that you trust to act on your behalf like that.
David, you're speaking my language exactly. I was a big proponent of the springing power of attorney and was incredibly disappointed when the legislature did away with it. I still don't understand why they would do so, but you bring up the other point I always mention. You need to trust your power of attorney, because that is a person who has the authority to act on your behalf. So don't go naming somebody willy-nilly. Make sure that it is somebody you trust with your financial affairs.
Right.
So one thing that always comes up when we're talking to anyone, actually, it doesn't have to be seniors, is you always hear them, you hear the television, you hear the professionals all say you must have a will, and a lot of people still don't have a will. And I think they get confused between what is the difference between a trust and a will, and what's the benefit of one or the other.
Well, we could spend a whole show or two just on that question alone. So I'm going to try to reduce my answer to something that's going to kind of fit in a little time frame here. So with a will, again, as I mentioned before, it's basically just the instruction manual for probate. We're telling the court how to put all the assets that are under an individual's name under a court-supervised collection and redistribution program, essentially, based on that instructions that are set forth in the will. And the will is only effective when a person passes away, and then the personal representative has to get appointed by the court, and the will itself is going to be a public document for the most part. And that is going to get submitted to the court and be viewable by anybody that would want to. Now, a trust, on the other hand, is generally a private document. All we submit to the courts is just a notice of trust, and then we say, well, have a nice day. We've just provided you notice that there's a trust. That's all we provide to the court. So whatever's in the trust itself is otherwise a private document. So that can be beneficial for some people. But we also have a trust if there's property, real estate property, that is outside of the state of Florida, usually, or wherever they reside. So that way we don't have to have what's called an ancillary administration in the other state there. And then also, a trust has the benefit of having a distribution method that is not going to be in a lump sum, distribution that a last will does. So the trust allows a more forgiving or extended period of time where you can have a devise over the course of up to 365 years or so. And so, that can be something that's useful, or you can have the trust distribute over a period, not just periodic, but also certain events. So when a person graduates from college or, has some other situations, that life events that are going to occur, then you can control that. I like to think of it as a hand coming up from the grave and being able to control, how those assets are going to be distributed over the course of time. Mm-hmm. And so, a trust used to be used more often than it is now because of the federal estate tax minimums. They've increased now to about $5.5 million. So a revocable living trust was used a lot more when we were down to $500,000 or so. And so under Florida law, which is all I can talk about, then, there's no estate tax, no inheritance tax, and we just have to deal with the federal estate tax situation there. So a trust is going to be potentially useful to cover that, but it's a rare situation these days.
Well, I know in our office we get a lot of people that come in because of probate. They're waiting for probate, and they've got mom and dad's house, and they're asking us